So here's a question. Do you file assignments at the provisional stage or wait until you file a full utility?
I'm going to let my friend JD over here handle this question.
Right?
Since,
This is
you're the patent attorney.
This is it, yeah. And I think what I'll say here is, just so in case anyone's wondering, assignments are when you transfer ownership from you as the individual inventor or inventors to an entity, a business entity, an LLC, a C-Corp. And the question is, there's two major types of applications that could get filed on the utility side, a provisional or a non-provisional. The provisional is the less formal version, and it can provide the all-important priority date, the first file date, and up to 1 year. And so during that time of pendency, yes, we do, upon request, if it makes sense, assign the application, right? That's a potential asset, but you can transfer ownership to an entity, even at the provisional phase. I haven't done it recently. Can it be done? Yes. Do we recommend it? Only if they're going to market. I think would it make sense, right?
Gotcha.
It's kind of one of those things that, okay, what's the point of it? And
Right.
you want to wait for things to matriculate.
Unless they're trying to commercialize it right now, bring on other investors and assign it during the process.
Yep.
So that's different than trademarks. I'll just quickly talk about the trademark side of this question.
For sure.
Make believe there is one.
Yeah.
But if you file an actual use application, so you've already gone to market with a product or service, and you're filing a trademark at the USPTO during the application process, which, here in 2024 takes about 14 months.
Yeah.
12 to 14 months. You can transfer or assign the trademark to a third-party entity. So you can do it. Yep.
Okay.
During the application process. However, if you file an intent to use application, meaning that you're not in the marketplace yet, but you're going to be, you may not assign that trademark application to a third-party firm until you submit your proof of use.
Okay. Interesting.
So that's something that trips up a lot of attorneys that I've seen.
Yeah.
They'll file an assignment for an intent to use application, get denied by the USPTO. So.
Yeah, what do you think the policy reason is there? Maybe is there anything much to it?
Yeah, I mean, I think that they don't want people prospecting, right? They don't want people filing trademarks and then just selling them to a third party, right? Basically holding the spot for people.
Oh, interesting. Right. Kind of like a domain squatter, if you will.
Yeah, I think that's part of it. But if you get back to like the policy perspective, right? It's not possible for a third party to have a bona fide intent to use the product or service if they didn't file the trademark themselves, right? So at the time of filing, the initial filer, the initial owner of the trademark application or the intent to use application had to have a bona fide intent to use. But obviously the third party that they assign it to or sell it to isn't going to have that same bona fide intent to use. So I think that's really what the issue is.
I like it. Well, Philip commented on I believe it was on my answer on the patent side. So he's a practitioner. He files assignments once he's carried out a full inventorship determination, which I think is really good. That is an awesome discussion that does happen. And sometimes it's forgotten. It's like, hey, if you're a solo inventor, did you invent all of this? Is anyone else involved, right? Is anyone else going to come out of the woodwork and say, you know what, I invented part of this? Let's get everybody together. And, only then I think that I agree. That makes sense. It's okay. Are we all going to assign this to one entity? Then there's some further considerations to be made where you want to probably recommend a business attorney, to draft the, founders agreement, operating agreements where all individuals the inventors, can be on the same page with respect to any money put in or expectations for payouts, ROI. It's a really good idea too for the attorney, because what can happen is business, partners break up. And so what's cool is if you represent the company now, you don't have to fire your client, right? You have one, party can leave. You can represent, one inventor. You don't need to represent all of them. You represent the company and the company's best interest. So it's a pretty cool play. Good call, Philip. Thank you for that.